Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. As my subscribers here admit, there are very few people in the world who are as polarizing as Donald J. Trump. At the heart of his classified information case is the fact that there is classified information generally, and unfortunately the media has done a very bad job of explaining not only classified information, but also how information gets classified to begin with. Before I actually get into the Trump national secrets case, which is going to be another video, I am going to do this video specifically on the classification of classified information. And that's important because unless you understand the levels and how information gets classified and how it gets declassified, then you really can't understand the issues that are extant in the Trump case. I have obtained all of this information directly off the internet, including the information about signals intelligence. It's right there on the NSA's website. But I want to make sure that you understand that I don't believe any of this information is itself classified. I'm simply telling you that all of this is important in terms of this national security case. And again, the media has done a very poor job of explaining any of this. Classification level must be assigned to information when that information is determined to be classified. A classification level indicates the relative importance of classified information to national security, and it thereby determines the specific security requirements applicable to that information. Because there are separate levels, clearly defined levels are essential to a classification system. The U.S. Classification of Information System has three classification levels: top secret, secret, and confidential. And they're defined by an executive order, that one that I mentioned earlier, 1, 2, 3, 5, 6. Those levels are both for national security and atomic energy information. So here's what the EO states. National security information, hereinafter classified information, shall be classified at one of the following three levels. Top secret shall be applied to information, the unauthorized disclosure of which reasonably could be expected to cause exceptionally grave damage to the national security. If I could depart for just a moment here, that is a vague description of classified information. It's vague. How would a person know what could reasonably expected to cause exceptionally grave damage? It might not cause damage at all, and it might cause catastrophic damage. There is nothing that tells somebody who is a classification authority how to grade this information with any degree of specificity. So let's go on. Secret shall be applied to information, the unauthorized disclosure of which reasonably could be expected to cause serious damage to the national security. Confidential shall be applied to information, the unauthorized disclosure of which reasonably could be expected to cause damage to the national security. So Section 1.1b of the EO states that except as otherwise provided by statute, no other terms shall be used to identify classified information, which is also not true. Why is that not true? Because there are separate levels of classification for something called code word intelligence. Now, code word intelligence is usually signals intelligence or communications intelligence that has been obtained through the use of radio equipment or satellites, that sort of thing. Here is a copy of an intercept from the National Security Agency's Cryptologic Museum showing, in this particular case, a code word document. The problem with saying that there's only three levels forgets that there is this code word. In addition to that, there's specially compartmented information. And so when this EO speaks in terms of three and says, except as otherwise provided, no other term shall be used to identify classified information, it is either out of date or just wrong, one of the two. If the disclosure of information causes net damage to the nation, then the information should at least be classified as confidential. However, like I said, there's very little available guidance to help determine which classification level should be assigned to classified info, whether it should be assigned as confidential, secret, or top secret. Now, examples of exceptionally grave damage included in the executive order were armed hostilities against the United States or its allies, disruption of foreign relations vitally affecting the national security. For example, the information from Bradley Manning, which went out, which had a whole bunch of cable information, diplomatic cables and stuff that cast the United States in a very bad light. The compromise of vital defense plans or complex cryptologic and communications intelligence systems, the revelation of sensitive intelligence operations, and the disclosure of scientific or technical developments vital to national security. Let's read a little bit from Section 1.2 of that particular executive order. The authority to classify information originally as top secret may be exercised only by 1. The President, 2. Agency heads and officials designated by the President in the Federal Register, and officials delegated this authority pursuant to Section 1.2d. Limitations on classification. This is Section 1.6. In no case shall information be classified in order to conceal violations of law, inefficiency, or administrative error, to prevent embarrassment to a person, organization, or agency, to restrain competition, or to prevent or delay the release of information that does not require protection in the interest of national security. Basically, that means the taxpayer has paid for this information, and if they want it, they can get it, as long as it doesn't harm national security. But of course, that's never been the case, and even the Freedom of Information Act has so many different exemptions that normally when you request a document or something like that that even touches on intelligence work, the majority of the document, except maybe the title, is redacted. So then Section 3.1 of that executive order talks about declassification authority. Now, you have to remember at the outset that an executive order comes from and is signed by the President. And so, as the chief classification authority, you would assume that he has the declassification authority too. But that's not how it's spelled out in the actual executive order. However, that would be what we in the law would call an implied power. If you can classify it, you can certainly declassify it. But here's what the EO says about declassification authority. Information should be declassified or downgraded as soon as national security considerations permit. Agencies shall coordinate their review of classified information with other agencies that have a direct interest in the subject matter. Information that continues to meet the classification requirements prescribed by Section 1.3 despite the passage of time will continue to be protected in accordance with this order. Now, this is interesting because there used to be something called a general declassification scale. So information shall be declassified or downgraded by the official who authorized the original classification if that official is still serving in the same position, the originator's successor, a supervisory official of either, or officials delegated such authority in writing by the agency head or the senior agency official designated pursuant to this order. If the Director of Information Security Oversight determines that information is classified in violation of this order, the Director may require the information to be declassified by the agency that originated the classification. Any such decision by the Director may be appealed to the National Security Council. The information shall remain classified pending a prompt decision on the appeal. Another reason that this is an implied power of the President is because the President controls the National Security Council. The National Security Council doesn't control the President. I should hop out here for a war story. The Pueblo was seized by the government of North Korea. And at the time, President Nixon, who was the president, actually made a mistake and revealed some very sensitive information on national TV when he was answering a reporter's question. So the actual agencies that control this classified information, the CIA, the National Security Agency, Department of Energy, the FBI, all of those agencies tend to close hold the information. One of the reasons that the National Security Council authorizes the president's daily brief is so that the president is aware of all the things that are going on. But here's the key thing. If they say it appears that North Korea is getting ready to test another missile, what they don't say is we learned that by signals intelligence, or we learned that by satellite imagery, or we learned that because we've got a mole deep in the North Korean military. They don't tell the why or the how. They just say this is what is. They give the what, not the why, not the how to the president. That's one of the reasons why this is done in that particular way. Now, there is a mandatory review for declassification. Except as provided by Section 3.4, all information classified under this order or predecessor orders shall be subject to a review for declassification by the originating agency if 1. The request is made by a U.S. citizen or permanent resident alien, a federal agency, or a state or local government, and 2. The request describes the document or material containing the information with sufficient specificity to enable the agency to locate it with a reasonable amount of effort. However, Section 3.42b, information originated by a president, the White House, by committees, commissions, or boards appointed by the president, or others specifically providing advice and counsel to the president or acting on behalf of the president is exempted from the provisions of Section 3.4a. Here's what the EO says about who can access it. A person is eligible for access to classified information, provided that a determination of trustworthiness has been made by agency heads or designated officials, and provided that such access is essential to the accomplishment of lawful and authorized government purposes. So what does that mean? That means you have to have a security clearance, and the security clearance is actually granted to you by the government organization that you are working for. So that's how you get classified, or I should say security clearances, in order to have access to classified information. The last part of that is the key part. Even though I had a security clearance when I worked in the military, I could not just walk into any briefing and say, hey, I want to hear about this. Now, they held a general briefing for anybody who wanted to come in the morning every day, and the briefer would talk about information, and then at some point he would say, okay, unless you have access to specially compartmented information, you have to leave now. And that's because those people did not have a need to know. The need to know is, without a doubt, more important than the security clearance. And that's because one of the functions of government with classified information is compartmentalization. If the NSA develops intelligence on China and it relates to missions that might be accomplished by the Army and the Navy, they get that information. But the Department of Energy won't get that information because it doesn't have a need to know. So that's what I have for you today. If you have any questions, leave them in the comments down below. If you have the opportunity today, do something kind for somebody, and then, if you would, come on back down here and catch me at the beach again tomorrow. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.